November 14, 2025, Yucatán Peninsula, Mexico, 41 nautical miles southwest of Isla Mujeres. 6 fast boats ran dark across the Gulf. No lights, no radio traffic, engines throttled back to cut acoustic signature. Each vessel carrying between 300 and 400 kilograms of compressed product, sealed in submersible-grade packaging. The convoy had been moving for 90 minutes out of a transshipment point near the Belizean border. Total estimated cargo value, $47 million at Gulf Coast wholesale rates. The boats were working a corridor that had stayed clean for 26 months, same route. Same timing windows, same this IDO silence. The network running this operation had refined it through repetition until it ran like logistics. Infrastructure, not improvised criminal engineered transport. At 2:19 a.m., the lead pilot checked his GPS. 38 minutes to the handoff point. Diesel reserve adequate. Weather nominal. He had no reason to think anything was wrong. He had no way of knowing that 900 feet above him, a military-grade surveillance drone was tracking every vessel in the convoy. That the drone had been repositioned from the Strait of Hormuz theater 72 hours earlier. That the reason it was here, watching 6 small boats on a dark stretch of Mexican coastline, was a crisis 6,000 miles away that had nothing to do with drug trafficking. In 41 minutes, all 6 boats would be stopped, cargo seized, pilots in flex cuffs on the deck of a Coast Guard cutter. The Hormuz blockade made this possible. The cartel never saw it coming. To understand what happened off the Yucatan in the pre-dawn hours of November 14th, 2025, you need to understand the architecture that kept the convoy invisible for 2 years. The operation had a name in DEA case files. Corriente Larga. Long current had been running since September 2023, originating from distribution infrastructure built around the Eastern Caribbean transshipment corridor. Product moved north out of South American source regions, staged through island networks in the Western Caribbean, and funneled into Gulf approach lanes via small boat transport. The core innovation was not the product or the route. Both were standard. The innovation was the surveillance suppression layer the network had built around itself. Starting in late 2022, the organization began acquiring detailed information about U.S. and Mexican maritime enforcement patterns in the Gulf, patrol schedules, sensor blind spots, drone deployment windows. The information came from multiple sources, corrupt officials inside Mexican federal maritime agencies, and commercial shipping contacts who could observe Coast Guard and Navy movement patterns from legal vessels. DEA analysts would later describe it as the most sophisticated maritime counter-surveillance package they had encountered at the cartel logistics level. The network did not try to outrun enforcement, it timed around it. Convoy windows were selected based on a rolling database of observed enforcement asset positions. When a helicopter was known to be operating in one sector, the corridor shifted. When a Coast Guard cutter had recently patrolled a lane, the convoy avoided it for a minimum of 72 hours. The system was manual, updated by phone, maintained by a logistics coordinator based in a city on Mexico's Yucatan coast who tracked maritime traffic like a shipping dispatcher. For 26 months, it worked without a single interdiction. Then a fuel cargo began moving through a sanctioned Iranian vessel off the Venezuelan coast. Everything changed. The connection between Corriente Larga and Iranian sanctions evasion was not apparent until late September 2025. It emerged from a financial intelligence thread that had nothing to do with drug enforcement. The Office of Foreign Assets Control, OFAC, had been monitoring sanctioned Iranian petroleum exports for 18 months. Iran's crude production had continued despite multilateral sanctions, and the product was reaching buyers through intermediary vessels, falsified certificates of origin, and port facilities in jurisdictions that didn't honor U.S. secondary sanctions. In August 2025, OFAC analysts identified a recurring transaction pattern involving a Cyprus-registered trading company and a series of fuel transfers in the Eastern Caribbean. The trading company was a shell. Behind it, a Tehran-linked energy intermediary on the SDN list, designated sanctioned operating anyway. The fuel was moving in smaller quantities than Iranian crude typically traded, not supertanker volumes. Parcels of 20,000 to 40,000 barrels at a time, transferred ship to ship in international waters, and then sailed into ports that asked few questions. What OFAC noticed in September 2025 was that some of the receiving vessels were operating in the same geographic corridor as known cartel transshipment traffic. The overlap was not coincidental. A financial analysis request went to DEA's Special Operations Division. The question, was there a relationship between the sanctioned fuel movement and any known trafficking organization? It took 3 weeks to establish the answer. It was yes. What DEA analysts found was a logistics exchange that had developed organically over approximately 14 months. The cartel network running Corriente Larga had expanded its revenue base by offering a service. Maritime protection corridors, safe passage coordination through lanes where cartel operatives had established relationships with local officials and could suppress scrutiny. In exchange for access to these corridors, the Iranian-linked intermediaries provided something the cartel found useful: subsidized fuel. Fuel was a significant operational expense for a fastboat network running hundreds of nautical miles per convoy. The cartel consumed it in quantity. Iranian petroleum sold below market through intermediaries who needed to move product and didn't care about the buyer cut the network's operating costs in a meaningful way. It was not a formal partnership, no contracts, no organizational integration. A transactional arrangement between two organizations that each had something the other needed, connected through intermediaries who took a percentage and maintained the fiction of distance. But the transaction left traces. Wire transfers through nominally clean accounts, fuel delivery records, vessel movement logs that place sanctioned cargo near known cartel, transshipment points, not enough for prosecution on its own, enough to confirm the relationship existed. The joint DEA-OFAC investigation expanded in October 2025. Three agencies now had equities, and the Department of Justice's National Security Division, which handled sanctions enforcement at the criminal level. The FBI's Financial Crimes Unit was read in. U.S. Coast Guard intelligence received a parallel brief. The investigation had a problem. The cartel's counter-surveillance architecture was effective enough that maritime interdiction had failed for 2 years. Every attempt to position enforcement assets in the convoy's operational area had been detected, and the corridor shifted. The network was reading enforcement presence faster than enforcement could adapt. That problem was about to be solved by a geopolitical event the investigators had no control over. On October 11, 2025, the Islamic Revolutionary Guard Corps Navy initiated what would become known as the Hormuz Constraint Operation. Iranian forces deployed mine-laying vessels, fast attack craft, and surface-to-ship missile batteries to positions that threatened commercial traffic through the Strait of Hormuz. In response, U.S. Central Command repositioned significant naval and air assets to the Persian Gulf theater. Among the assets repositioned, multiple high-altitude maritime surveillance drones that had previously been operating over Atlantic and Gulf of Mexico patrol areas. The redeployment was not announced, it was not public, but a surveillance architecture doesn't become invisible when it moves. It leaves a gap, and the cartel's counter-surveillance coordinator, tracking maritime enforcement asset positions from a monitoring operation on Yucatán coast, saw the gap. What he did not know was that the gap was being filled. Within 72 hours of the Hormuz repositioning, Southern Command coordinated an emergency deployment of substitute surveillance assets through a classified program that kept the replacement invisible to the commercial maritime tracking sources the cartel relied on. The substitute drones was operated at different altitudes on different transponder profiles. They did not appear in the tracking data the cartel's coordinator was watching. From the network's perspective, the surveillance architecture over their operational corridor had thinned. From the actual surveillance perspective, coverage had maintained near continuity. The cartel logistics coordinator read the reduced signatures and made a recommendation. Accelerate the November convoy. Move the November 14th scheduled run as planned. The window was as clean as it had been in months. He sent the go signal on November 12th. The DEA Special Operations Division received intelligence about the planned convoy movement within hours. A human source embedded in the logistics layer, not in the operational cell, but close enough to the scheduling function to have access to timing information, had passed the departure window, 41 nautical miles. November 14th, pre-dawn, 6 vessels. The operational plan moved from intelligence collection to interdiction planning within 24 hours. DEA's Maritime Interdiction Authority in international waters operated through the State Department's Bilateral Maritime Agreement Framework with Mexico. The U.S.-Mexico Bilateral Maritime Counter-Narcotics Agreement allowed U.S. forces to operate in Mexican territorial waters with coordination notice to Mexican authorities and in international waters adjacent to the Mexican EEZ with standard notification protocols. The legal framework was not complicated. The execution was 6 fast boats moving in open water without lights presented a targeting problem. The convoy would be spread over several nautical miles. Interdicting all 6 simultaneously required enough assets to cover the entire formation, and the vessels were fast enough that any alert, any radio call, any engine up could allow some of them to scatter. The plan required simultaneous stops of all 6 vessels within a compressed time window. Coast Guard cutter Steadfast was repositioned from its patrol area in the eastern Gulf to a holding position 40 nautical miles north of the convoy. Projected track. 2 smaller Coast Guard response boats were pre-positioned under cover of darkness. A DEA Air Wing aircraft carrying night vision-equipped agents loitered at altitude with a Navy P-8 maritime patrol aircraft maintaining the primary surveillance feed. The drone tracking the convoy since shortly after departure fed continuous position data to the P-8, which relayed it to the Steadfast Combat Information Center. The convoy's course and speed were being plotted in real time. At 2:31 a.m., the Steadfast received the interdiction authorization. The operation was already 14 minutes old. The convoy was 34 minutes from its handoff point. In the decision meeting that preceded the authorization, one question had required resolution. The interdiction was taking place in Mexican water, and the Mexican Navy had not been part of the operational planning for security reasons. The compromise was a notification protocol. Mexican Naval Command received a call from U.S. Embassy attaché channels at 2:28 a.m., 3 minutes before the interdiction was authorized. Not a request for permission. A courtesy notification under the bilateral agreement, with a request for a Mexican naval vessel to proceed to the area. The Mexican Naval Response Vessel would arrive 2 hours and 11 minutes after. The interdiction was complete. At 2:34 a.m., the P-8 crew identified all 6 convoy vessels in formation. They had held their course without deviation. The counter-surveillance system had not detected the surveillance assets above them. The Coast Guard response boats moved to intercept positions at 2:36 a.m. They approached from the north using the convoy's own engine noise as acoustic. The Steadfast came south at speed to block any northward retreat. The DEA Air Wing aircraft descended to support boarding operations. The 6 convoy pilots had 30 seconds of warning. One vessel attempted to turn and run south. It was overtaken within 4 minutes. The other 5 stopped on first contact. No shots fired, no injuries. 6 vessels, 6 crews. Cargo confirmed on all 6 boats. Total product weight, 1,847 kilograms. Estimated wholesale value. If you're still watching, and this case goes significantly deeper than what happened on water, subscribe now. The financial layer behind this operation is where the real investigation started. The product seizure was the visible event. The investigation that preceded it and the investigation that followed operated on different tracks. The prosecution track was straightforward by federal maritime narcotics standards. The 6 vessel operators were transferred to Coast Guard custody, transported to U.S. jurisdiction, and processed for arraignment on federal narcotics trafficking charges. Their cases moved through the Southern District of Florida, which handled the majority of Gulf maritime narcotics prosecutions. The intelligence track was considerably more complex. What DEA and the National Security Division had documented by the time of the interdiction was a sanctions evasion architecture that extended well beyond the Corriente Larga network. The cartel's role had been logistical. The Iranian-linked intermediaries were the principal sanctions violators. But the investigation had identified a third layer that was more significant than either. The fuel transactions had moved through 3 financial institutions, one in Cyprus, one in the United Arab Emirates, one in Panama. All 3 had processed transactions involving sanctioned Iranian entities. None of the 3 had filed the suspicious activity reports required under their respective jurisdictions' anti-money laundering frameworks. This was not negligence. The analysis team's conclusion, based on transaction patterns and timing, was that at least 2 of the 3 institutions had been aware of the source of the funds and had processed the transactions anyway. What do you think? Does this represent a failure of the international financial system? Or is this an inevitable outcome when sanctioned actors have enough money to find compliant institutions? The answer matters more than any single prosecution. Financial institution liability for sanctions violations is a different category of federal case than narcotics trafficking. It falls under OFAC civil enforcement, and in criminal case, DOJ prosecution under the International Emergency Economic Powers Act, the penalties scale differently. A narcotics trafficking prosecution puts individuals in prison. A financial institution prosecution can result in billions in forfeitures and compliance orders that reshape how a bank operates globally. The Cyprus and UAE institutions were outside direct U.S. criminal jurisdiction. OFAC could impose civil penalties. Access to the U.S. financial system could be restricted, but criminal prosecution required conduct that touched U.S. territory or U.S. financial infrastructure. The Panama institution was different. It maintained a correspondent banking relationship with a U.S. bank. Transactions had cleared through that correspondent relationship. U.S. jurisdiction attached. By November 20, 2025, DOJ had opened a parallel grand jury investigation targeting the Panamanian institution. It was separate from the Corriente Larga prosecution. Different assistant U.S. attorneys, different evidentiary record. The cartel prosecution was the surface case. The banking investigation was the substrate. The surface case moved quickly. The 6 vessel operators were arraigned in Miami by late November. Their attorneys entered not guilty pleas. Federal prosecutors filed a motion establishing the evidentiary record for maritime jurisdiction. Precise GPS coordinates of each vessel at the time of interdiction, the flag status of the vessels, the bilateral agreement framework. 3 of the 6 operators began cooperation conversations with prosecutors before December ended. What they provided was consistent in its general architecture and inconsistent in its operational details, exactly what you'd expect from individuals who each had a different slice of visibility into the network. None of them knew the logistics coordinator by name. None of them had direct contact with anyone above the cell supervisor level, but the aggregate picture they provided confirmed what the investigation had already assembled from intelligence sources. The logistics coordinator was a man in his late 30s, operating from a coastal city in the Yucatán. He had been the network's scheduling and counter-surveillance function for approximately 18 months, replacing a predecessor who had been arrested in a separate investigation. His operational security was good. He used encrypted communications. He did not keep records in ways that created straightforward digital evidence. The investigation had his approximate location. It did not yet have his identity with the certainty required for a federal warrant. That changed in January 2026. One of the cooperating operators provided a detail that had seemed peripheral at the time he gave it: a meeting location. Not a meeting he had attended directly, but one he had been told about by his cell supervisor. A specific restaurant in a specific city, referenced as the place where scheduling decisions were communicated before convoy windows. DEA Mexico City attaché coordinated with Mexican federal law enforcement. Surveillance on the restaurant began January 8, 2026. It produced nothing immediately useful. The coordinator, if he was still using the location, was not visiting frequently. On January 19th, a surveillance team member made a routine notation about a vehicle that had parked near the restaurant on 3 separate days without entering. Different parking positions each time, close enough to the entrance to observe who came and went. Counter-surveillance. The coordinator was there. He just wasn't going inside. Mexican federal authorities, coordinating with DEA, arranged a discreet vehicular surveillance on the observation vehicle. It led, over 3 days of careful work, to a residential address outside the city center. Not a registration, the vehicle was registered to a shell company, but a physical location. A full surveillance package was established by January 24th. The address was under continuous coverage. The coordinator was identified by February 3, 2026 through photo comparison with informant-provided descriptions, cell phone signal analysis, and one compromising moment when he made a call while standing at a window that gave the surveillance team a clear facial image. His name was Ernesto Valdez Morales, 41 years old, a former commercial shipping logistics manager who had transitioned to cartel employment approximately 4 years earlier. His background in legitimate shipping was what made him effective. He understood vessel tracking, port scheduling, and maritime sensor architecture from the inside. Valdez had one significant operational security failure. He used a single encrypted messaging application for both his cartel coordination and a personal communication thread with a family member in another city. The personal thread used a registered account linked to a real phone number. Through legal process and cooperation between U.S. and Mexican authorities, investigators were able to use the registered account to correlate device identifiers and ultimately to link his encrypted cartel communication account to the same device. Months of encrypted cartel communications became available for analysis. The content confirmed the surveillance evasion architecture in operational detail. It also contained references to the fuel arrangement, described obliquely in terms a reader would not immediately understand, but specific enough that, read alongside the financial intelligence the investigation had already assembled, they were unambiguous. It confirmed one additional element the investigation had not fully established: the timing of the decision to run the November 14th convoy. Valdez had made the call based on the surveillance gap created by the Hormuz repositioning. His messages to the operational cell supervisor on November 12th referenced reduced overhead coverage in explicit terms. He had seen it as an opportunity. The operational window was better than anything in the previous 6 months. He recommended moving forward. The Hormuz crisis had not created the cartel network. It had not created the Iranian fuel arrangement. What it had done, for approximately 48 to 72 hours, was create the conditions that made Valdez confident enough to run a convoy he might otherwise have delayed. His confidence was the error the investigation had been waiting for. The obstacle that nearly derailed the interdiction itself was navigational and logistical. When the Steadfast moved south to its blocking position on the night of November 14th, it encountered an unexpected cluster of commercial fishing vessels operating without full lighting compliance in the area between its departure point and the interdiction zone. Maneuvering around the fishing fleet while maintaining stealth took 11 additional minutes. The P-8 crew calculated that at the convoy's current speed, this delay would compress the available interdiction window. If the blocking position was not established before the convoy reached the projected handoff point, some vessels might reach shallow coastal waters where Coast Guard response boats could not safely operate at speed. The solution was a course correction that took the Steadfast south and west on a longer arc, bypassing the fishing fleet entirely and arriving at the blocking position from a different vector. It cost 13 additional minutes and consumed fuel reserves the mission plan had not accounted for. The Steadfast arrived at its blocking position 4 minutes before the interdiction was initiated. Margin, 4 minutes. If the convoy had been running faster, or if the fishing fleet had extended further west, the operation would have required a contingency execution with fewer assets in position. The operational briefing document noted this and recommended that future mission planning for Gulf maritime interdictions include a 15% time buffer for surface traffic in the target area. Recommendation noted implementation dependent on future mission planning decisions. By March 2026, the Corriente Larga prosecution had 15 defendants, the 6 vessel operators plus 9 individuals identified. Intelligence work including 2 cell supervisors and several logistics support personnel. Valdez was not among them. His case was more complicated. The evidence linking him to the convoy was strong. The evidence for the cartel prosecution was strong. But DOJ and the State Department were managing a parallel diplomatic track with Mexican authorities about how his eventual prosecution would be structured, Mexican or U.S. jurisdiction, extradition considerations, and what cooperation credit he might receive if he chose to provide information about the Iranian fuel arrangement. As of the most recent filings in the case record, Valdez remained under surveillance in Mexico. No arrest had been executed, no extradition request had been formally filed, the Panamanian banking institution's case was in the grand jury phase. No indictment had been returned. The institution's management had retained U.S. counsel and entered into preliminary discussions with DOJ about a potential deferred prosecution agreement. The negotiations were ongoing. The Cyprus and UAE institutions had received OFAC compliance letters. Civil monetary penalty negotiations were underway with each. Neither had yet resulted in a public settlement. The Iranian-Linked fuel intermediary network identified in the OFAC investigation had its node, the Cyprus Trading Company, formally designated as a blocked entity in December 2025. 3 individuals associated with it received personal designations. Their assets subject to U.S. jurisdiction were frozen. The underlying fuel distribution network, operating through entities outside the designated list, remained operational as of the latest available intelligence. Will the sanctions designation actually stop the fuel from moving, or does it simply add another shell company to a chain that already had a dozen? Comment below, we read every. The open questions in the Corriente Larga case file extended beyond the individuals who had not been arrested. The maritime counter-surveillance database Valdez had maintained, the system that tracked enforcement asset positions and kept the corridor clean for 26 months, had been accessed by the investigation but not fully reconstructed. The database resided on an encrypted server whose physical location had been identified but whose contents required decryption work that was ongoing. As of early 2026, more significant, the database had users other than Valdez. Other trafficking networks had purchased access to his surveillance schedule. The investigation had identified 3 other organizations that had been paying for corridor timing information. Their convoy movements, occurring in different windows than Corriente Larga's but coordinated against the same enforcement schedule database, were not part of the November 14th interdiction. They were still running. How much product had moved through that corridor over 26 months, and how much of it was from organizations paying for schedule access but otherwise unconnected to Corriente Larga remained unknown. The DEA's estimate, based on frequency of known convoy movements and average load weights, was in the range of 30 to 40 metric tons of cocaine equivalent. A rough number, the actual figure could be higher. The three organizations with database access had been identified but not yet charged. The investigation into them was in its earliest phase. The human source who had provided the November 14th convoy timing remained active. Their identity was protected. Their continued cooperation was conditioned on the investigation's ability to maintain the source's cover, which required, among other things, not proceeding with certain prosecutions at a pace that would allow the network's remaining members to identify how the information had leaked. The source had been inside the network's logistics layer for approximately 8 months before the November interdiction. The DEA's assessment was that the source had generated actionable intelligence on at least 6 planned convoy movements, of which the November 14th operation was the first to result in interdiction. The other 5 movements had been allowed to proceed unchallenged to protect the source. An unknown quantity of product had moved through the Gulf in those 5 windows while investigators watched and did not act. This was a standard operational trade-off in long-term infiltration cases. It was also the kind of decision that does not appear prominently in press releases. The tactical success of the November 14th interdiction was real. $47 million in wholesale product off the water, 6 vessels, 15 defendants in federal court. A surveillance evasion architecture exposed and partially dismantled. The structural elements that made the operation possible, the sanctions, evasion pipeline, the financial institutions that processed the transactions, the counter-surveillance database still being accessed by other organizations, remained in place, in varying degrees of disruption. As of the spring of 2026, the Hormuz dimension of the case had been assessed by DOJ and OFAC analysts in a classified review completed in February 2002. 6. The assessment's core finding, the Corriente Larga Iranian fuel arrangement, was not an isolated case. The mechanism, cartel logistics infrastructure exchanging corridor access for commodities or services the sanctioned party needed to move, had been observed in at least 2 other geographic contexts in the Western Hemisphere. Different cartels, different sanctioned actors, different commodities. Same structural logic. An organization under enforcement pressure needed movement capability, and a criminal logistics network was positioned to provide it in exchange for something valuable. The February assessment did not establish that this represented a coordinated Iranian strategy. It assessed that it was more likely a pattern of opportunistic commercial transactions, each arranged independently, than a directed program. The distinction mattered legally. It did not change the security implications. If sanctioned actors have learned that cartel logistics networks are available for hire, and that the arrangement can be structured to maintain plausible deniability on both sides, the pattern will recur. The demand for it exists on both sides. The Hormuz crisis exposed one instance. The instances that weren't exposed remain opaque. The 6 vessel operators prosecuted in the Southern District of Florida received sentences ranging from 8 to 14 years. 3 who cooperated received the lower end of that range. 3 who didn't receive the higher end, standard federal maritime narcotics sentencing. The cell supervisors identified in the subsequent investigation phase faced separate indictments. Their cases were pending trial as of spring 2026. Valdez Morales remained unindicted, under surveillance, the subject of ongoing extradition discussions between U.S. and Mexican authorities. The logistics coordinator who built the most effective maritime counter-surveillance architecture, DEA Special Operations Division, had documented at the cartel level was living in a house in a coastal Mexican city, aware that he was under pressure, unclear on the exact dimensions of the case against him. The drone that tracked his convoy was back over the Strait of Hormuz within a week of the November 14th operation. The Hormuz situation remained unresolved. The corridor his database served continued operating on a reduced and more cautious schedule, run by people who did not yet know what had been taken from their system. The network is fractured. The demand that built it has not changed. Subscribe if you want to follow the banking investigation when it produces public filings. That case is where the larger numbers are, and it's moving toward resolution. The surveillance database is still being decrypted. The 3 client organizations using it for corridor timing are still under investigation. Valdez is still out there. One detail in the case record is worth noting without elaboration. The fuel arrangement, once established, ran for 14 months. 14 months of transactions. The first month of those transactions took place 3 months before the DEA had any intelligence indicating the relationship existed. The network was ahead for over a year before anyone knew to look for it. That number, 14 months, is the one that matters most to the analysts trying to determine whether similar arrangements are currently running somewhere in the Western Hemisphere that no one has identified yet. They do not know the answer.